There can only be one reason why they have refused to bring that evidence, because it points to the innocence of the accused. Jowie Joseph Irungu is innocent and we shall prove it. Of course, the sentence has been passed. We were expecting something close. We are not shocked. And let me whet your appetite. I think all of you remember those words. Those are not my words. Those are the words of the Honorable Lady Justice Nzioka when she was passing the sentence on Jowie. We all remember those words. Let me whet your appetite. We affirm in our belief that during this whole process, the Honorable Lady Justice, with respect, was playing to the gallery and aiming at placating the court of the public. And this is why we are adamant in our belief that that judgment delivered in court, completely and substantially different from the written judgment, because it was made to placate the public. Jowie is innocent, and at the Court of Appeal, we will be vindicated. The notice of appeal is ready. We're just waiting for a little time to maybe further discuss before we proceed. But one thing is clear. The Honorable Justice built a mountain out of the clothes that Jowie wore, especially those brown khaki shorts. She had to build a mountain on those shorts. Why? Because those are the only things that she had that would link Jowie to the death of Monica Kimani. Purportedly because a drop of blood was found with Monica's DNA on those shorts. That was the only link, apart from all the rubbish circumstantial evidence. That was the only link that this court had to lay its case on. But then, were those the same shorts that Jowie wore? The defense was adamant that those shorts which were exhibited in court were not the same shorts that Jowie wore. The prosecution's own witness said that the shorts that Jowie had on had side pockets and were brown khaki. The shorts that were brought into court purportedly with DNA did not have side pockets. These were different shorts. On 3 occasions, when Justice Wakiaga was handling the matter, he asked the prosecution to bring evidence of the pictures of the shots that they took while they picked those shots from Jackie Mariba's house. The pictures that were taken with Jowie holding onto the shots, clearly showing the side pockets. 3 times, the prosecution refused to bring those shots, those pictures into evidence. 3 times. Why? During his evidence, the DNA expert claimed that he took pictures of those shots through the whole process. But when asked to bring the pictures of those shots to court, again, refused. Why? It is rather obvious. Our courts have always held that where the prosecution refuses to bring evidence before court in their own possession, which might prove to be exculpatory evidence, there can only be one reason why they have refused to bring that evidence, because it points to the innocence of the accused. Jowie Joseph Irungu is innocent and we shall prove it. Thank you.
arrive at the sentence that will eventually be pronounced in this matter. So the recognized principles of sentencing include: 1, minimum intervention. What does it mean? It means that an accused person, a convicted person, must benefit from the less severe minimum sentence. The second principle, and for the lawyers, we find this expounded in depth and simply picking up the summary there. So before I go to the second principle, I draw attention to the fact that this principle of minimum intervention is amplified and recognized in our Constitution, and I draw your attention to Article 50 of the Constitution of Kenya that says that an accused person should be given the benefit of the least severe sentence, and especially if there has been change in law in relation to that sentence between the time that accused person was tried and at the time the court is pronouncing its sentence.